A federal court cannot simply answer legal questions because they are important. Plaintiffs must prove they belong there by crossing a rigid constitutional threshold. That threshold is found in Article 3, Section 2 of the Constitution, which limits the power of the federal judiciary to actual cases and controversies. Under the Lujan standard, a case requires an injury in fact. The harm must be concrete, particularized, and actual or imminent. It cannot be a guess about the future. It must be what the court calls certainly impending. If a plaintiff cannot meet these requirements, the courthouse doors remain shut. The court will not hear the case, no matter how much the law was violated. Congressman Michael Bost challenged an Illinois law allowing mail-in ballots to be counted for 2 weeks after Election Day, if postmarked by the deadline. But there was a timing problem. Bost filed his suit before the election happened. No votes had been cast, and no illegal ballots had been counted. This created a procedural dilemma. How can a candidate prove an injury is certainly impending before the counting even begins? The Supreme Court heard the case, but the consensus on standing broke apart. The justices divided into 3 separate legal frameworks explaining why Bost sued. The disagreement in Bost signals a shift in how the court views political actors. By the end of this case, the unified standard for standing was replaced by 3 conflicting paths to a federal courtroom. Chief Justice John Roberts wrote the majority opinion. He refused to require that Bost prove he would lose the election before suing. Roberts argued that candidates have a unique, particularized interest in a fair process, an interest fundamentally different from an ordinary citizen. He compared it to a 100-meter dash. If the track is unexpectedly extended to 105 meters, every runner is harmed, deprived of the chance to compete in the race they prepared for. This logic separates the competitors from those in the stands. Voters may have a general interest in a fair count, but the candidate has a distinct personal stake in how the result is determined. Roberts had a pragmatic reason. He pointed to the Purcell principle, warning courts against changing election rules at the last minute to avoid voter confusion. If judges demand proof that a rule changes the outcome, candidates must wait until the eve of the election to sue, risking entire process destabilization. The majority redefined an election injury. It is no longer about the risk of losing, but rather the denial of a fair competition. Justice Amy Coney Barrett concurred in the result, but rejected the majority's reasoning. She called the idea of a special standing rule for candidates bespoke. In her view, politicians are not special litigants. They must follow the same rules as anyone else seeking to enter a federal court. Barrett found a simpler path to standing through pocketbook harm. Bost spent campaign funds hiring poll watchers to monitor the extra 14 days of counting. She looked to a case involving Monsanto. When a statute creates a substantial risk of harm, like GMOs contaminating organic crops, a plaintiff has standing if they spend money to mitigate that risk. The logic matches Bost's case exactly. A statute creates a risk of invalid ballots. The candidate spends money on poll watchers to mitigate that risk. That financial loss is a traditional Article 3 injury. By focusing on money, Barrett avoided giving politicians special status. She treated the campaign like any other business managing a regulatory risk. Justice Ketanji Brown Jackson's dissent framed the majority as creating a policy exception that the Constitution does not allow. She argued that an interest in a fair process is not particularized. If the election rules are wrong, everyone is harmed. That makes it a generalized grievance, which federal courts cannot hear. She also challenged Barrett's pocketbook theory using a case called Clapper. The court previously ruled that a plaintiff cannot manufacture standing by spending money to avoid a harm that isn't certain. For Jackson, Bost's spending was based on speculative fear. The 14-day rule didn't harm him. He just worried it might eventually lead to a smaller margin of victory. She cited Los Angeles v. Lyons, where a man illegally choked by police was denied standing for an injunction. He couldn't prove he would be choked again. The court has been notoriously strict on this point in the past. In Jackson's view, the court abandoned its own precedents and the requirements of Article 3 to accommodate the pressures of an election cycle. Returning to the logic tree, the unified Lujan standard has divided into 3 distinct, incompatible branches. The threshold for pre-election lawsuits has effectively been lowered for those on the ballot. This fracture highlights a tension between Roberts' desire for early stability and Jackson's insistence on judicial restraint. Jackson warned that this would lead to a flood of litigation. If candidates no longer have to prove an actual risk of losing, federal courts can now be used to micromanage everything from ballot fonts to chain of custody procedures. For litigators, this means a candidate can now enter federal court without proving they are likely to lose the election. The injury is considered present the moment the competition rules are set. Exhaustive modeling of election outcomes is no longer required at the start of a case. Candidate status and a credible allegation of an unfair process now provide sufficient grounds for federal jurisdiction.